All right, I think that timer is my cue to start. So with that, I will say again, welcome to everyone, and thanks for being with us. Today in our WATES webinar, and WATES, by the way, is an acronym for What Are the Experts Saying? We have three great panelists, and we're going to talk about financial industry cybersecurity. So a question and an issue on a lot of people's minds. So again, thanks for being with us in the latest of our series of WATES webinars. I'm Jenna Ellis, and along with Dan Totolo, we are your moderators. If you have questions during the webinar on the document panel or on the control panel, you'll see a chat feature. If you have any questions, please feel free to chat the question to Dan, and you just drop down the send to and then type your question in. We'll answer any questions you may have that we can during the webinar, or after the webinar. We will pass those along to the experts after toward the end of the webinar. So feel free to do that. And then I want to answer one question that always comes up, which is you will definitely get these slides in email form after the presentation. So, you know, no worries about that. People always ask, and you definitely will get them. So with that, our panelists here, we have three of them, really lucky to have them. They are experts, and we have, like I said, we have three. The first is J. Preston Carter, and Preston Carter is a writer-analyst with the banking group here at Wolters Kluwer Legal and Regulatory. And we have John Pachowski. John is an attorney and senior banking analyst, and he works and tracks and also explains banking developments for Federal Banking Law Reports and the Banking and Finance Law Daily. And thirdly, we have Mark Nelson. Mark's a writer-analyst for our security publications here at Wolters Kluwer, and he is also a leading provider of corporate and, of course, securities information. So, gentlemen, thanks so much for being with us.
Thank you, Jenna.
Thank you, Jenna.
Thank you.
So let's just jump right into this. There's a lot of stuff to cover and a lot of different facets of cybersecurity. There's a white paper that we like to think of as kind of the companion. The webinar and the white paper are companion pieces about this issue. And if you haven't downloaded it, again, you'll get that you'll get the white paper in the email that'll come after this, but a lot of really great details about what we're going to talk about today. So just wanted to point that out as well, that the three of you have authored that white paper. And also, you three have also worked on and continue to update and follow what's new. For our audience, you've likely seen a lot of our smart charts, but if you see screenshots and slides that look kind of like this and you haven't seen it, these are smart charts, and they're available on our Cheetah platform. And again, you will be getting slides of these charts, et cetera, that the three experts here update in the deck that you'll get in the email at the end. So the first real chunk of this webinar, we want to really devote to New York State. And Preston, New York State was really, was really the first to establish these cybersecurity requirements for their financial industry, right?
That's right, Jenna. The New York Department of Financial Services, the DFS, issued the first comprehensive state cybersecurity regulations requiring banks, insurance companies, and other financial services institutions to create, establish, and maintain a cybersecurity program. The regs are their first of the kind in the nation, and they were several years in the making, and of course in response to the financial services industry's increasing concerns regarding cybersecurity risks. If you're wondering why New York is the first one to come out, well, Andrew Cuomo might have hinted at it when he said, New York is the financial capital of the world, and it is critical that we do everything in our power to protect consumers and our financial system from the ever-increasing threat of cyber attacks.
And these regs took effect March 1st, if I'm correct.
Yes, they do. They came into effect March 1st with a lot of there are a long list of requirements institutions have to comply with, and a great first number of those come into effect August 28th.
And that's 180 days. And when we talk about all of these, these regulations, who has to be in compliance? It seems like there's a lot of exemption.
Well, the regs require, they call them covered entities, have to comply. And this is any entity that is supervised by the DFS. Generally, that's banks, insurance companies, financial services institutions. The DFS supervises about 25 different types of institutions. So if the DFS is your regulator, you are required to comply. And the regs also apply to many third-party vendors of licensed institutions, such as service providers and application providers.
Are there a lot of detail in these exemptions? Or if someone is exempt, do they know who they are, or is it written, in broad language, or is there, is there a chance for it to be too vague?
Well, the exemptions are based on a company's number of employees, its gross revenue, and its total assets. Also, certain insurance companies are exempt from some requirements. The thing about exemption is that a company has to file a notice exemption within 30 days of determining that it is exempt. So there's some question about exactly what that means, determining that you are exempt. So institutions need to, if they think they're exempt, they should be examining that question right now.
Okay. And let's say that as an entity, you're not exempt. You have to follow these regulations. What are they looking for? What are they looking at as being in compliance in this first deadline?
Well, the first deadline, as we mentioned, is August 28th. And I would say that there are a number of things you have to do by then. The three big ones, I would say, is appointing a chief information security officer, and establishing your cybersecurity program, and adopting a policy. An organization ought to have its CISO, its CISO in place right away, because this is the person who's going to oversee and implement the program and enforce the policy. The company can hire outside of the company, though, and the person doesn't have to have that CISO title. But they have to be qualified, and they'll be in charge of assembling the team that's going to make sure that the program complies with regulation.
So that's kind of a couple highlights from this August 28th, and that's the first compliance deadline. What about some of the others? Any other ones that you wanted to point out as far as the rest of the dates go?
Well, February 1st is another important date. That's when the first of the annual certifications of compliance has to be submitted. And that has to be submitted by the chairperson of the board of directors. And then after that, the next big date is March 1st. And the CISO's annual report to the governing board comes in then. And the risk assessment is due on March 1st. And this is another very interesting point. On August 28th, the cybersecurity program and policy have to be in place. But these are to be based on the company's assessment of its cybersecurity risk. And this risk assessment itself doesn't have to be completed until March 1st. So companies should be advised that even though that's not required until March 1st, they are going to have to accomplish a great deal of that in order to set up an appropriate program and policy. Also on March 1st, other things include the vulnerability assessments. They'll have to set up their multi-factor authentication for getting into information. and establish cybersecurity awareness training for all their employees. Employee error is still the major cause of cybersecurity breaches.
And I think you brought up a good point, which is that these aren't just standalone dates. A lot of these are continually building on things and actions that they've had to they've had to comply with in the past. So it's not something that they want to wait till a couple of days before and then get a start on, right? They have to continually be building on on the actions of the prior dates. So, how has this gone over with these entities? Has there been pushback? What have the entities said?
Well, when the proposed regs came out last year, there was significant pushback from bankers and other industry stakeholders and the American Bankers Association. Many people thought that the regs were too prescriptive. They wanted a one-size-fits-all for the covered entities. So the DFS listened to the concerns, and the final regs are much more based on an organization's own assessment of its own risks. However, there are still concerns. For instance, the American Bankers Association remains concerned that these regs are still going to be a significant burden on banks, and that the short compliance window, August 28th, is coming right up, isn't going to give banks enough time to get their systems in place. And then there's also the continuing concern that regulations aren't going to provide enough flexibility to address the ever-changing, evolving nature of cyber threats.
And so what if something happens and someone can't comply or they don't comply? They don't pay attention to these deadlines. What happens?
Well, the regulation doesn't have penalties in it, but it does provide that it is enforced by the superintendent of financial services. And, that's the organization that's going to allow you to do business in the state. So I think it's certainly in a company's best interest to do all they can to comply. Also, we're discovering in litigation that courts are more willing to give a company that's suffered a cyber attack the benefit of the doubt if it can show that it has followed all the rules in place and done the best it can to prevent an attack. We're aware that if a company hasn't suffered a cyber attack yet, it's going to in the future. So as long as you do your very best to cover all your bases, you'll be better off if you have to go to court over this.
So New York is really the front runner. They have all of these regulations and these compliance check-in dates. Any other states talking about this? Any movement from them?
Well, I'm sure they're talking about it, just as we saw state after state pass their own data breach laws over the past few years. I'm sure that other states are going to get into the cybersecurity law and regulations business also. New York's the big state, of course, and everyone's looking to what it has done. Its rules are already being referred to as setting forth what may become best practices in cybersecurity. So if other states start passing their own, I believe we could see them being quite similar to New York's.
That definitely makes sense. And one of the things Preston kind of left off with is, different lawsuits and how the courts interpret things, and kind of how, if you haven't suffered a breach, you probably will in the future. So if we turn to federal banking and, how this works in the federal banking arena, John, can you tell us about there was this global payment system breach with the Bangladesh bank that cost millions of dollars. What happened there?
Well, that was a hack in early 2016. The Bangladesh bank, where there was a pay order sent to the Federal Reserve Bank of New York to withdraw up to $1 billion. from the Bangladesh bank's account at the Federal Reserve Bank of New York. Fortunately, it was stopped at only $81 million because there was a red flag, a word in the payment order that raised a red flag that stopped any other further withdrawals. This is probably not the impetus of why the agencies took action in October of 2016, where they sent out an advance notice of proposed rulemaking seeking comments on enhanced cybersecurity risk management standards for certain financial institutions. That notice made mention of the interconnectedness of the financial system. And when I saw that word, I think more of what happened at the height of the financial crisis, or just at the beginning, actually, with the bankruptcy of Lehman Brothers and all the panic and contagion that it spread through the financial system in this country, and then eventually it seemed that went global as well. I think that's the concern with the this notice that the OCC, the Fed, and the FDIC sent out, that certain banks with their various business relationships with each other, if there's a cyber hack, some sort of cyber event, that it can imperil not just their systems, but then it can just start a domino effect to these other banks, and then just it could conceivably shut down the financial services system in the country. So I think that's the reason why this notice was sent out by the agencies at the time.
And that notice, the comment period for that notice closed in February.
Correct. And the agencies collected a number of comments, and they were, I guess they're still in the process of looking them over. And the comments came from a wide variety of stakeholders. And you had trade organizations that represented various sizes of financial institutions, banks. You had some service providers. These proposed, if these standards ever come into effect as written, it would affect any type of bank that has an asset threshold of $50 billion. And there are only a number of those, according to most recent data I looked at, like 3 dozen or so that would be affected at this point. It would also cover service providers of these various financial institutions. And in fact, one of the comment letters was from a service provider saying, don't make us part of the, don't have us adhere to these standards as well. The way the third-party risk management regulations are set up, or supervisory guidances are set up by the agencies, would adequately cover the service providers in this area. So that's the other. Oh, sorry.
No, go ahead. Sorry.
I was going to say the other comment letters, say from trade organizations that represent larger banks, they said, well, look at the risk profile of the institutions that you would want subjected to these standards, and tailor the standards to those risks. Same thing with smaller banks, banks with less than $10 billion, commonly referred to as community banks. I mean, they're concerned as well, you're setting this standard for these types of banks. Is that going to eventually just trickle down, or are we going to be responsible for these standards as well? Our risks are nowhere near what these bigger banks have. So our exposure to cybersecurity or cyber events is not as great as these 36 or so banks. That's where the comments fell right now.
Right. So it's kind of obviously on both sides, as we would expect. Right. So where do we go from here, I guess, with these rulemaking releases? What's the next thing that's going to happen?
Well, the next thing is, as I said, this was just an advance notice of proposed rulemaking. The agencies are just trying to start getting the outer contours of what these standards should be. And from these comments, their staff, the agency staff members, staffers, will go and start refining the language, refining the standards, how they should be applied, how they should be applied. Should it be a straight-up regulation? Should it be just standards and guidance, that type of thing? That's where we're at right now. There has been no movement whether there's going to be a notice of proposed rulemaking where these comments would be integrated into the language. So that's where we stand at this point.
And you mentioned kind of the staff deciding, and is there, we've heard kind of, especially with new administration, et cetera, that there might be a lot of vacancies. How does that affect this?
Well, they're right. We had the change in administration, so there's two things with the Trump administration starting up in January. One, you had some regulators or heads of regulatory agencies, say, for instance, the OCC, the controller's term expired in May. There's an acting controller now. Somebody was put forth to be nominated just a week or so ago. So that's one agency. The Fed's another one. They have three governors right now, I think, seated, and there's supposed to be up to 7. And one of the vacancies is for bank supervision, vice chair for bank supervision, and there's been names bandied about for that. The same with the Federal Deposit Insurance Corporation. There might be an opening there as well. There also may be 1 or 2 of the other board members, maybe their terms may be expiring also sometime during the Trump administration. That may slow down the regulatory progress of these standards. You also have a number of administrative actions that President Trump has taken since he started his term. And you have one action was what they call the 1 in, 2 out rule. You know, if an agency proposes one new rule, they have to find 2 rules to take out. Basically sort of a balancing act. The second one was an executive order in February where he called for the Secretary of the Treasury to do a review of financial regulatory regulations. And that review ended earlier this month, and in fact, the Treasury Department just put out a report yesterday on its findings and its recommendations. And there is one little part about cybersecurity there. And basically it just said that the agencies, federal and state regulatory agencies, should have processes that they should be coordinated. Their regulatory tools, their examinations should be coordinated. And then any type of regulation should have a common, they call common lexicon. And any other regulation, anything else should be, any interpretations, guidance, harmonized. Since the agencies have already acted on an interagency basis, and the language would probably be, there would be common language with just subtle changes to meet each of the regulators' supervisory role, I think though the suggestions or recommendations in this paper or this report that came out would be met. So that's no problem there. Again, it's just a matter of staff bureaucracy moving forward.
Right.
I don't think anything else, any of the other administrative actions or executive actions should impede the progress of these standards. Well, it's just a matter of staff getting together, putting it forward. I also okay. Sorry.
It's definitely, I was going to say, it's definitely something, you know, that you'll be able to be watching and tracking and writing about.
Yeah.
So, you know, there's all of these proposal comment periods, but then if we look, okay, so that might happen in the future, or, you know, is the beginnings of what's going to happen. What are we looking at right now? What are these, you know, what's in place now federally?
Well, any bank that has some sort of federal regulator, and most banks either being federally chartered or state chartered, has some federal supervisory impact upon them. And there are some things that the agencies have already done or do on an ongoing basis. One is each institution is rated for their information technology framework, and that's part of the examination process, and they get graded on that. There's an umbrella group of the federal regulators called the FFIEC, Federal Financial Institutions Examination Council. They have a number of tools that help banking institutions meet their cybersecurity and their information technology obligations. There's a handbook by the FFIEC that gives guidance to the examiners. Well, if that's what the examiners are looking at, the bank should be looking at what the examiners are looking at. That's one resource there. Banks, again, they're all under an obligation also to have information security standards, and that goes back to the Gramm-Leach-Bliley Act in the late 90s, and this is the safeguard financial institution, the customer information at these financial institutions. And then finally, again, another FFIEC tool is their cybersecurity assessment tool, and it allows them to determine how prepared they are for a cyber attack or a cyber incident. So there are some resources out there already.
And I don't expect you, and I don't expect you to have a crystal ball, but can we predict a timeline, or is it up in the air?
I actually looked at the most recent there. Each agency is required to put out a semi-annual regulatory agenda, and I looked at least for the Fed and the FDIC, and the last time it was put out that I was able to find was in the fall. There should have been one out for the spring, and I've seen no movement whatsoever at this point. So we just have to keep just keep watching.
Monitoring it, yeah.
Yeah. I mean, the FDIC generally has a meeting every once in a while, a board meeting where they'll discuss regulatory activity. And if they say something, if they're acting on it, and it's an interagency type of thing, the Fed and the OCC are sure to follow shortly thereafter.
Right.
So that's,
that's kind of the timeline, I guess. Then.
Yeah.
What we're watching.
Right.
So if we flip over to the SEC and the CFTC, they've both already adopted regs, and those regs are specifically focusing on cybersecurity systems, control.
That's correct, Jenna. The SEC and the CFTC have both adopted similar regulations. The SEC's version is called Regulation Systems Compliance and Integrity, or Regulation SCI. This is basically a codification of the agency's older automation review policy. Regulation SCI applies to what are called SCI entities. These would be entities like self-regulatory organizations, alternative trading systems, securities information processors or plan processors, and some exempt clearing agencies can fall within the ambit of Regulation SCI. The CFTC has actually split its regulations into two branches. One is what's called the exchange rules that apply to designated contract markets, swap execution facilities, swap data repositories, and there's a separate set of clearing rules for derivatives clearing organizations. In the adoption of Regulation SCI, the question had come up for the Commission as to what to do about duly registered entities, and the solution is relatively simple. It's they comply with Regulation SCI for their securities activities and with the CFTC's equivalent regulations for futures activities. And before I move on to another point that I want to make, I'll just make a note here about some of the compliance states for both of these rules. On Reg SCI, the compliance states have all passed, but there is a special compliance provision for alternative trading systems. They do not have to comply with the rule until 6 months after they newly meet the volume threshold set forth in Regulation SCI. As for the CFTC side of the ledger, Only some of those compliance dates have passed. There are some more that are due this September, and there's actually another compliance date for designated contract markets and swap data repositories regarding their key controls testing that extends all the way out to September of 2019.
Mark, I want to, kind of move on to NASA, but I also wanted to point out for you attendees, if you are interested in even a deeper dive into this regulation SCI, definitely download the white paper. There's a lot of information that Mark supplied, as well as, charts, et cetera, with the dates and compliance and rules in that white paper. So if you haven't already, definitely do so. But Mark, let's move on to NASA, and they've weighed in and created some model rules, and I think that was, in April of 2015.
Right. NASA, which is that's the organization that represents state securities regulators, they've more recently adopted a policy statement on electronic offering documents, and as you mentioned, they have also put forth a model rule and guidance regarding investment advisors with respect to business continuity and succession planning. I believe a small number of states, I think 3, have actually adopted that model rule, and there may be as many as 4 states that are considering adoption. I know NASA also will be doing a cybersecurity roundtable later this month, so certainly cybersecurity is still foremost among blue sky practitioners and regulators as well as at the federal level. But I think the more interesting developments perhaps in the blue sky arena have actually occurred in a couple of individual states. About a month ago, Colorado proposed a regulation that would require broker-dealers and investment advisors to have written policies and procedures that are reasonably designed to ensure cybersecurity. It's kind of a broad requirement, and there's several criteria or factors that Colorado regulators could look at to gauge compliance. The regulation also would require that investment advisors and broker-dealers include cybersecurity in their risk assessments that they make to regulators. It's an interesting development because it comes, fairly close after New York adopted its regulations on cybersecurity for banks, and it also mirrors very closely a regulation adopted about a year ago in Vermont.
And what about other states? Are other states kind of following suit, or we're looking at
there's some activity in a small number of states. At this point, with the exception of Vermont and Colorado, where the proposal and the adopted rules actually are very, very much alike, there tends to be quite a bit of variety. And Minnesota, for example, has some provisions on cybersecurity, but they are different in scope and breadth from the Vermont and Colorado regulations.
When John was talking about federal banking, he talked about the Trump administration, kind of executive branch, and when we talk about your content, and we really want to make note of Congress and introducing some cybersecurity bills.
Right. Congress, of course, in the late 2015 omnibus, they did adopt some more general rules about reporting cyber events to Congress. But, so far the activity on security-specific legislation has been relatively sparse. I know in the last Congress, now former Congressman McDermott introduced a bill that would have required public companies to provide Sarbanes-Oxley type certifications about their cybersecurity activities. And that bill, to my knowledge, has not been reintroduced in the current Congress, but a different bill introduced last Congress and now reintroduced in the 115th Congress and sponsored by Senator Jack Reed of Rhode Island would impose some additional disclosure obligations on public companies. This is a bill, it's known as S-536, and it would require SEC to adopt rules requiring public companies to disclose whether any of their board members have expertise or other experience with cybersecurity issues. If they don't have a board member with that type of expertise, then the company would have to disclose what are called the cybersecurity steps they have taken in evaluating nominees for positions on their governing board, whether it's a board of directors or a general partnership.
And what about how this flows into, corporate governance, M&A, some of those other arenas? There's been a lot of, news and cases in court regarding this issue.
Sure. Yeah, one of the perhaps emerging areas could be the mergers and acquisitions setting. Not too long ago, we saw the Verizon Yahoo deal revalued at a lower price by about $350 million due to several data breaches that had come to light at Yahoo's operating company, which was the piece of Yahoo that Verizon was acquiring. It didn't ultimately affect the deal so far. The parties even agreed that particular disclosure would not be a business material adverse effect. But again, it's a deal that was valued much more highly, and after further negotiations, when these disclosures came to light, it was lowered significantly, and I think it currently stands at about $4.5 billion. Another area to keep an eye on is shareholder suits against companies that have data breaches. There have been several of those, and I'm only going to mention two due to the limited time today. And the first one is the Target case. Most of those suits have been dismissed, but there was a very recent settlement between Target and 47 state attorneys general for about $18.5 million. It's a significant settlement, not just because it happened or because of the amount, but because the requirements imposed on Target by the settlement in some ways mirror much of what has been imposed on banks under the New York regulation. And I think Preston had mentioned, New York is potentially becoming a source of best practices. So it's probably worth taking a look both at the New York regulation and at that Attorney General settlement with Target over their data breaches. Another case is the one against Home Depot. This was one filed in the federal district court in Atlanta. That case had been dismissed and then appealed to the 11th Circuit, but there is a pending proposed settlement in that case. According to the terms of the settlement that I've read, it looks like the shareholders would like to impose some additional governance changes on Home Depot to improve the company's oversight of cybersecurity matters.
And then how about briefly, Morgan Stanley and Archie Jones? I was hoping you would touch on those too.
Definitely, we certainly can. On the enforcement arena, as far as the SEC is concerned, I would say companies should kind of keep in mind some slightly older regulations. One is Regulation ID and the identity theft red flags that it lists. Companies also should keep in mind a Regulation SP, which contains Rule 30A, which is also known as the Safeguards Rule. And it's here on the Safeguards Rule where the SEC's enforcement focus has primarily been trained. As you mentioned, there was a case against R.T. Jones and another one against Morgan Stanley. In the R.T. Jones matter, that involved an unknown intruder who obtained access to data. R.T. Jones agreed to pay a $75,000 civil money penalty to resolve the matter. In the Morgan Stanley Smith Barney matter, that involved an employee who misused his access to customer data in order to browse a larger set of customer data than he was authorized to do. He then stored that data on a personal server that may have been hacked. Morgan Stanley, Smith Barney resolved that matter by being censured and paying a $1 million fine. It's significant that the amount of the fines seem to be on an upward trend, although that's also based on the facts in the case and as well. And in terms of SEC enforcement, I would say, one recommendation I would have is for people to go back and look at some of the older cyber exam sweeps that the agency's Office of Compliance, Inspections, and Examinations did. They're quite informative. I would also urge them to keep an eye on the enforcement priorities at OC, because cyber security is something that seems to show up annually nowadays, and also to keep track of the risk alerts. OC issued its most recent one after the WannaCry ransomware made its rounds about a month ago. So, I think it's always good to keep an eye on those risk alerts, because they often contain some good information on recent events.
And that's what you're looking forward to.
Have in mind.
Yeah,
absolutely. We will. Sure, we will continue to track securities and banking issues on cybersecurity as they develop.
Great. Well, thank you so much to all three of our experts today. A lot of information covered and a lot of continued tracked information. Let's see, Dan, do you actually, before I get to your question, I had a question emailed to me, which is, what if I'm advising a bank located in a state just doing business in New York? Do I have to comply? Do they have to comply?
Yes.
Anyone?
If a bank is doing business in New York with, I think it'd be safe to comply if you're doing business in New York, because even law firms that are representing banks in New York are being advised to make sure their cybersecurity program is meeting the requirements. The problem is, if you're dealing with a New York institution, there are backdoor ways for hackers to get into that institution's information through you, and you're still going to end up being liable. So as Mark mentioned, the best practices issue is probably a good idea for anyone doing any kind of business in New York to check out these regs.
Great. Dan, any other questions in the chat feature?
Yes, there was, actually, and I think this question is also for you, Preston. The question was, is there a set schedule of monetary penalties for non-compliance with the NYCRR?
No, monetary penalties were excluded from the regulation. Those penalties would come into play through another avenue of DFS enforcement, but not through the regulation itself.
All right, great. Thank you so much again to everyone who attended the webinar, and of course, thank you, our three experts. We really enjoyed having you, a lot of information. And I want to reiterate again, you'll get the slides and also the white paper via email. There is also just a really brief survey. I think it has 5 questions, but I use these to determine what interests you guys going forward, our attendees, and the topics you might like to see a WATES webinar cover. So if you have 30 seconds to fill that out, that would be great and much appreciated. So again, thanks to everyone for attending, and thanks to our experts today.